Good afternoon, everyone, and welcome. We have another great turnout today. We ask that if you have any questions, you enter them in the Q&A. I know we have a lot of content in a short period of time to cover it, but we will try to get to as many as possible. Please continue to keep an eye out for additional webinars to help you stay up to date. We have muted everyone and request that there may not be any IA recording tools used during this meeting, but we do appreciate you taking your time to join us for the information to be unpacked in this presentation. And with that, Taylor, I will be turning it over to you.
Awesome. Well, thank you very much. And today we're going to go over the Pregnant Workers Fairness Act. We're going to go over some associated laws with you all as well. And we're doing this because we have a passion for small businesses. And we really just like making sure that everyone's aware. We want to help, as much as we can. And as far as we can, we've been in business for 25 years, and I'm the director of operations here. We really appreciate you all joining today, and we're just going to do a deep dive into the PWFA for you. So appreciate you kind of having this on your radar, as it's very important and something that we really want to make sure that everyone's aware of. So give me just 1 second here. All right. So again, we're going to touch on the PWFA. Those associated laws that we mentioned are going to be the ADA, the PDA, the Pump Act, and FMLA. Just going to touch on some state laws as well. And of course, what we come to you for is giving you best practices to keep you safe. So things to make sure that, we're thinking about along the way. I'm going to go ahead and turn my camera off so we can focus on the presentation. And so here we go. So the Pregnant Workers Fairness Act, this is something goes into effect on June 18th. So it's upcoming, and this is affecting a lot of companies. So this is kind of a big change, something that a lot of people need to be made aware of, because you'll see here it does require employers with 15 employees or more to make accommodations if someone requests them in relation to what you see here: pregnancy, childbirth, or related medical conditions. And that related medical conditions is certainly kind of a big add-on. There's a lot of different things where we'll kind of unpack what that means, how closely related to these items it needs to be. The accommodations, we'll go into defining the accommodations as well. Then there, at the end of the day, just changes in the work environment or the way that things are usually done at work. And so with these accommodations, one thing to note is that generally the burden is on the employee to raise the need for an accommodation, and then the employer must respond. And so an employer is not, expected to know without being told what degree the impairment or impact on job performance or any kind of need for an accommodation without being told by the employee. Different things affect people different ways. So it's always important to note that this is something that we're kind of waiting to understand how this is affecting a particular employee. One exception to this rule, where the employer should be the party to initiate the interactive process, is when, the employer knows that they have a disability, or that they have reason to know, or, reason to know the disability prevents the employee from requesting that accommodation. So if they physically cannot request that accommodation, then it's then it's a situation where the employer should kind of be aware of this. So if someone's, of course, visibly pregnant, then you're aware that they're pregnant, right? So think about when those things are obvious. We don't want to ask why, you need this accommodation or things like that. If the individual you're talking to is clearly pregnant and asking for a reasonable accommodation as well, you'll see that's bolded here on the screen because we are talking all day about reasonable accommodations, right? We're talking about things that can still make sure that it works with the employer and it works with the employee. So this is going to be a balancing act. We're going to be looking at, some specific situations. Every situation is going to be different though at the end of the day. So important to just make sure that we have an understanding of what's expected from us as an employer, and making sure that we know the next steps if this conversation were to come up. And so this is actually a poster that is on the EEOC's page online. So we put this here so that you're aware of how this is communicated to the employee, right? How this information is made available to the employee. So the question posed is, if your pregnancy, childbirth, or related medical condition makes it harder for you to perform your job, you can ask for a change called a reasonable accommodation. And so this is kind of how it walks you through. So if this happens to you, then number one, talk to your employer, your manager, HR, whoever is designated in company policy, and just kind of get the conversation started, right? It says covered employers must provide a reasonable accommodation unless it will cause an undue hardship. And we'll get into those hardships. But then number two is explain that because of a physical or mental condition, you need a change, right? And that's physical or mental. And then share with your employer what barriers you are facing. Give ideas if you have them for what could help you do your job. And then of course, number four here is a big part of why we're adding this. This is if your employer says no, then provide the information. Tell them to go to this website. So it's always important to know how this is being portrayed to your employees. And it is important that, that they have resources to reach out. You see there's contact information here, kind of places to go for more information and next steps. But essentially what we're looking at is urging people, if you need a change, to go forward. And especially in number three, it says give ideas, give recommendations. You may need to do your job differently, a piece of equipment breaks, leave, or a different schedule. So there's definitely options that the EEOC provides. And so we want to really let the employee lead this conversation. If they're going to come forward and say, hey, I need an accommodation, then okay, great. Well, what is it, what is it that you're experiencing, and what ideas do you have that could help us help you, right? So we want the recommendations to come from the employee first, because essentially they do their job day in, they do their job day out. So this is something that we want to kind of take their lead, because following this is going to be a more detailed conversation. As an employer, you are allowed to offer alternatives as long as they are reasonable. And this does, even on this poster, it says covered employers must provide a reasonable accommodation. So, understanding where the employee's headspace is at will help us find something that maybe if what they're coming forward with is unreasonable, then we can kind of give some alternate options, but also understand more about where their headspace is at and understand where and how this conversation can go forward from there. So again, and this is all governed, by the EEOC. So this is the same body that covers a lot of different laws that we're going to talk about today. and like harassment, things like that. So this is a government agency, that we're all familiar with what it is that they're putting out. And we want to be aware because there's laws that go along with these. And so, just to kind of break down further the pregnancy, childbirth, and related medical conditions. So, just to give you an idea, this can apply to current pregnancy, past pregnancy, potential pregnancy, lactation, including breastfeeding and pumping, use of a contraception, menstruation, infertility or fertility treatments, endometriosis, miscarriage, stillbirth, or having or choosing not to have an abortion, among other conditions. There is an extensive list that goes along with this, but I think, hearing just that one term does not necessarily bring all of these items listed here to the forefront of your mind, right? So this is something that we definitely want to give a second thought and make sure that this is not something that applies. Again, you can go to the EEOC website and get that full list, because it would include menopause as well. Contraception would be like maybe getting an IUD placed, recovery, any complications that might come from that. Endometriosis, abortion, if it's time to get one, if there's complications from, even perhaps the appointments that you need to have, going into and talking about the fertility treatments. So this is not something that's neatly placed inside a box, saying, pregnancy, because here it is, current, past, and potential pregnancy. So we have to think about this, from multiple different points of view to make sure that if we do have someone come forward and ask for something and providing a basis, that we understand and that, the people that we have trained to answer these questions and to speak on this policy are really thinking about it within these wide parameters. The related medical conditions is defined as new physical and mental conditions originating during pregnancy and pre-existing conditions that are exacerbated by pregnancy or childbirth. So again, this could be something that is just worse now because I'm going through a pregnancy, or this is something that, could have happened. Maybe I was pregnant, but now I have postpartum depression, right? But that still relates to the pregnancy, childbirth, and related medical conditions. The EEOC, includes in their list migraines and morning sickness and any kind of appointments, like I mentioned earlier, that could apply to this as well. So this is something, and again, this is a new law as well. So we really want to just make sure that we're thinking about this within the context that we're living in. This is something that, that comes up for a lot of people in the workplace. It's a very real potential, that this could come into play if you have 15 employees or more, right? And then, of course, we'll go along with how this law plays with others in a similar vein. But this one is going to be something that is very broadly defined. And these are defined as limitations. So this is going to be kind of a difference of where a limit is a limitation not seen as a disability, right? Because one of the laws we'll talk about is the ADA. So what makes this a limitation instead of a disability is that it needs to be temporary in nature, right? So meaning that the employee can perform the functions in the near future. Now, one thing as well is that they did not define a time frame, right? And they did this on purpose. So this is something that we don't ever want to go into this looking at, okay, so if I allow this accommodation 9 months from now, then I don't have to provide this accommodation anymore. That is not the case, because there's nothing defined. There's nothing that says, hey, it has to be temporary, defined by this many days, this many hours, this many shifts. So it is just something we're looking at that is temporary in nature, and that eventually the employee will be able to snap back and work, that position or perform that duty without the accommodation, quote unquote, in the near future. So we put that language here in quotes because it is directly from the law and how it's defined. Now, so if you have, in your particular workplace, if they're not eligible for FMLA or other state leaves, then this is something that we're going to approach as an accommodation question, right? So we're going to look to this law, because if we're above 15 employees, then this is the law that we're looking to, because this is the law that applies to us. But always important to keep in mind that the greater rights law applies, which just means that, yes, while we have this law and it is in place, if there is, for instance, a state leave that requires you to pay this employee while they're on leave, then that law applies. This one's not going to take precedent over that and say, well, all we have to do is give you an accommodation. So it's going to work and play. Always keep in mind that you need to, keep your eyes on the horizon and understand, the different federal and state laws that may apply to you, your company, and that particular situation of the employee, and make sure that we're applying all of those laws to the employee. If, we were to look and find that the best accommodation that we can offer is a leave, then do understand that this law does provide job protection. And there's other laws as well. We'll touch on those, but that job protection still does apply. You don't have to pay the employees if under the PWFA you talk with the employee and you agree that the correct accommodation is to take leave. But they do have that job protection while they are out, even though you are not required to pay them during that time. And so this is going to be kind of defining undue hardship. And it's going to be difficult, so we want to make sure, this is going to be one of those cases where we'll give you some guidance, but we want to make sure that we're also considering consulting with, professionals when the time comes, because each of these situations are going to be different. So you must make a reasonable accommodation unless it would choose an undue hardship on your company. So defining that is going to be, a little on the difficult side. We recommend speaking with a labor attorney, because at the end of the day, the employer has the burden of proof when it comes to claiming an undue hardship, which is the same definition with the ADA, meaning that I couldn't do that without significant difficulty or significant expense. And so always recommend kind of giving that a second thought, thinking about as well, that this is a new law, right? So we want to make sure that that we're considering everything, that we're crossing, our T's and dotting our I's, because we don't, at the end of the day, we don't want our name on the case law, right? So we want to make sure that we're stepping through this correctly. There will be, more examples coming. This law is certainly in development, as far as learning the implementations. So before just claiming that undue hardship, we really want to look at these reasonable accommodations and really make sure that we're quantifying what to offer and what the options are. And again, I mentioned a leave a minute ago, and a leave does qualify as an accommodation, but we definitely advise caution on this area. We only want to use this if there was no other reasonable accommodation available, and that this is something that was agreed upon between you and the employee during that discussion had, because This is pretty much the stated purpose of the law. The stated purpose of the law is to make sure that pregnant women, when they're on the job and they become pregnant, they're not being forced out of work and being forced to go on a leave when they really could have done the work, during that time. So we always want to keep in mind that yes, while leave is an option, remember the heart of this and where this law came from is that we want to make sure, and we want to make sure any, accommodation that we help would actually, that we offer would actually reasonably help, right? So we're not just going to go down the list and say, yes, I'll let you do this and this and this. We want to really make sure that this is something that's going to work as far as, serving the further purposes, allowing, the pregnant worker to continue to work. And then, of course, under the ADA, when we're thinking about, these different accommodations, under the ADA, the elimination of an essential function is not reasonable. However, it is with the PWFA. So this is a huge difference here, that with the PWFA, we're talking about a temporary condition, which, at a reasonable time in the future will cease. And then essential functions, when it comes to these accommodations, can be eliminated, can be moved and handed out to other individuals. A lot of different ways, and it will take kind of some creativity, but just because it's an essential function of the job does not mean that it is not subject to change when we're talking about reasonable accommodations under the PWFA. So really with ADA, again, they share the same definition of undue hardship, but the big differences are PWFA PWFA can be temporary, and then the ADA is a disability, which is more ongoing. And so some sample accommodations are going to be here on the board. We bolded the top ones here, so if the individual's always sitting, let them stand. The individual's always standing, let them sit. Allow additional bathroom breaks and just additional breaks to eat or drink. Allow them to keep a water bottle with them at all times. These are bolded because essentially the EEOC has already said that these cannot cause an undue hardship. So at the end of the day, if you have someone coming to you saying, hey, can I sit down at the front desk? Go ahead and offer the accommodation. Like these are kind of the alley-oops. These are the easy ones, that, hey, these are things we want to make sure that they're looked at as a given when it comes to these reasonable accommodations. And then just some more examples here. The EEOC provides, some additional examples also, but, light duty work, if you have that defined already, is a good kind of way to go. Schedule adjustment, if you're having morning sickness and you're always getting sick exactly in the morning, and I just need another hour to get to work, I'll work another hour later, but it happens at the same time. Remote work, temporary reassignment or suspension of duties. So this is where it comes up, even if it is an essential function of the job, then that temporary reassignment or suspension of duties is something to be considered as a sample, as an accommodation. And then transfer to a vacant position. So keeping in mind, you don't have to create a new position or promote them up in order to make this accommodation, right? Because we're looking at these as limitations. These are things that are temporary in nature. And so you're not required to create a position or promote them, but maybe transfer their work to what they're performing during this time until the temporary nature is over. And I know, a lot of us may be looking at the remote work on this list, and, have some opinions there, but one thing that we want to advise is that the first thing that they'll, that a lawyer would look at, right? If they're looking at this case and you're saying, hey, I couldn't offer remote work as a reasonable accommodation. Well, they're gonna say, hey, what did you do during COVID? So important to think about all the things that we all had to move around and make work and, and oftentimes change our entire business model, right? In order to make these things happen around COVID. So just understanding from, a lawyer's point of view, this is going to be something where you have set a precedent as far as what can and cannot be allowed in the past, even perhaps without realizing it, right? And again, with these situations, you can always recommend consulting with experts if you feel like none of these are options for you and you need to claim an undue hardship. And then we have the interactive process, which is just a term for the conversation. If you, an employee comes to you, the first thing that we want is to make sure that that employee is talking to the right person. I think that it's easy to be dismissive, like, hey, can I sit instead of standing all day? It's easy to say no and kind of, go about your day. And so some things to think about is we want to make sure, because this conversation, this interactive process is integral to making sure that you find that common ground and are able to use your creativity to find a way to make this work. But we want to make sure that the employee is talking with the right person. And so when someone comes to us and says, hey, I need this, reasonable accommodation according to the PWFA, they might even have that flyer in their hand, right? There are some things that we can and cannot do during this conversation. So if the pregnancy is obvious, well, you cannot ask why. Why do you need the accommodation? Or ask them for a document from their physician. The employee is allowed to self-confirm. So, if you're standing here and, in front of someone who's 5 months pregnant and it's obvious and say, hey, I need to sit instead of stand, don't ask why and don't ask for documentation. If they say that, let you know that they're pregnant, then that's enough there for us to start the process of finding out what it is that, they're looking for. So what do you recommend? Yeah, we'd be happy to start this conversation and discuss with you. What do you think would help you with, getting the job done at the end of the day? But then if the ask is more obscure, you can ask for documentation in a couple of situations. So if it confirms the physical or mental condition that is not obvious, so if there's like a back injury, swollen ankles, lift restrictions, or chemical avoidance, like, hey, I just can't be around these particular chemicals right now because I'm pregnant, that could be something. Or even if if they're not visibly pregnant, right, at that point. So we're assuming a couple things. We, if we're confirming that it's actually related to pregnancy, childbirth, and then we can ask to have the adjustment or change needed specifically documented there. So these are just going to be those more obscure things. This is not something you're expected necessarily to hand away, but if it's something that's obvious, and again, one of those easy ones that are, can I sit instead of stand, just for a temporary period of time, this is something that'll pass. Then we definitely want to just kind of jump right to those. That's a yes. That's a quick, easy yes. And so you also, in alignment with asking for documentation, you can't ask this person for a doctor's note if you wouldn't under normal circumstances, right? So you can't just say, hey, well, I need a document for that. But if someone else came and gave the same, back injury or something like that, you don't ask them for medical forms. So we want to make sure we're staying consistent with when we're asking for these forms, that is considered, well, what do we usually do? What did we do 6 months ago, maybe before this law was enacted? Would I have asked for a doctor's form then? And consider that when we're thinking about asking for documentation. And so again, we want the employee to provide what it is that they find reasonable. And we don't have to agree right then or there, but we do need to, say, okay, thank you, I'll consider these, and, kind of come back if you need to check and make sure, that's reasonable, or say, hey, I understand you can't do this part of your job. Let me consider, the options that you've brought forward on how to solve this, and make sure we can, at the end of the day, agree on something and find something reasonable moving forward. And so kind of coming into this, it's still helpful, to have a written job description that's prepared before advertising or interviewing for this job, as evidence of essential functions. We can't define the essential functions after the employee has already started. We want to make sure that this is something that we have in place before, because when we're talking about essential functions, some positions, hey, it might only exist just to perform this one function, or if you work in a silo and there's really no one else to hand this work to, if you can't do this one part of your job, there's no one else to hand it to. And the expertise or skill required to perform the function as well. If this is something that took, a lot of schooling, a lot of certifications, XYZ, then this is important to have on hand to understand, that we're defining these ahead of time, that this is what this position is there to do, and this is what, even the time spent per day performing this function. If you do this 7 hours a day and then you do the rest of your function, 1 hour a day. So these are cases where if you're looking to say, hey, this would cause an undue hardship, then this is something that's going to help you in advance, something that you could do right now, right, to make sure that you're prepared in the future if the situation comes up, to where these things can be easily defined and documented. Because at the end of the day, like we mentioned, the employer, the burden of proof is going to be on the employer. So if you're looking to file that undue hardship, instead of offering a reasonable accommodation, getting your ducks in a row as far as having these essential functions and job descriptions in place is really going to be the best thing for you as a company as a whole. All right, so now that we touched on the new law, we're just going to remind you about some other ones here. And again, the PWFA is going to be with 15 and up employees. And you'll see that there's some overlap on the left-hand side with under 20 and 15 and 15 plus. So this is just kind of here to show that there's a lot of different laws to consider. Some of them speak to each other. The PDA is the Pregnancy Discrimination Act. So that's kind of what allows that job protection as well. The ADA, we mentioned some of the overlap and the bigger differences. But again, just some laws to kind of have on your radar, because these are the ones on the federal level. And this is not even touching, all of the state laws that are going to be one-offs, and you have to consider what state that they're working in. And important to remember also that just in the year 2023, the EEOC received more than 81,000 new discrimination charges, and they obtained over $440 million for victims of employment discrimination. So that could fall under any of these laws, right? And we're only talking about some of them today. So compliance is going to be a big part of, making sure, especially as we have more workers that are remote, we're expanding into different states, we're growing, and we're happy about it. So here, this is just here to show some checkpoints along the way that maybe if you're at 18 employees, oh, we got to start thinking about the ADEA and COBRA when it comes to, getting our documentation together, because we're coming up on 20 employees soon. So we have to make sure we're covering, these different laws, the FMLA as well. And so we're going to jump into some of these federal laws and mention some state laws to you that kind of play with this PWFA. And so this is going to be the ADA. It follows the same parameters, as Title VII. So any kind of discrimination, for against individuals with disabilities, and this is from the hiring process, the firing process, throughout your tenure, and all your promotions. So this is something that we want to make sure that we're thinking about throughout the employee life cycle, right? Individuals under the ADA, should be able to perform those essential functions, even, if they need an accommodation, but they should be able to perform the essential functions of the job, which, as we mentioned, was different from the PWFA. It only asks if they need an accommodation, don't ask the nature or the severity of this. We say, can you, perform the essential function? Can you perform it with a reasonable accommodation? There is no kind of further probing, further questions, because we're only looking at this as far as the job in front of us. Can you perform, this job, essentially? So important that we don't delve into information that, first of all, we don't want to be responsible for. But second of all, asking too much information a lot of the time can be equal to discrimination under these laws. And then again, with the PWFA, is a temporary condition, with the ADA is defined as an ability. And this covers even if you're associated with someone with a disability, which again calls back to a lot of the language from the Title VII. So you see how kind of a lot of these play together. With the ADA, there's also requirements for your facility. If you own your facility, which we won't go into today, but there's just a lot of different things to think about. And just remember to keep any questions or comments based on the job functions at hand. And it's generally still with the ADA on the employee to ask for that accommodation. And of course, just defining, a disability with the ADA is they have a physical or mental impairment that substantially limits one or more of their major life activities, a record of such impairment, or has been regarded as having such an impairment. So again, it's it's all around us looking at this from many different points of view. And then the Pregnancy Discrimination Act, or the PDA. This is part of Title VII of the Civil Rights Act of 1964. So this was added on in 1978. It follows kind of the same pattern as PWFA, as 15 and up employees. And so essentially what this does is just because you as an employer don't have 50 employees and you don't offer FMLA, that does not necessarily mean that a pregnant worker's job is not protected when they go on leave. So this is going to be the other one, essentially, when we're looking at while employees are on leave. But it says an agency must permit a pregnant employee to do their job for as long as they are capable of performing the job. And it prevents discrimination in the way that you cannot withhold a promotion or terminate an employee because of childbirth or pregnancy. So we don't want to, have those discrimination charges when it comes to any of these, and again, the entire length of the employee life cycle. And we want to think about different state laws too, when it comes to these leaves of absence. The greater laws rule may apply. They may even have greater rights while they're out on leave, this even more than you cannot terminate an employee because of a pregnancy. Important as well to make sure that we're not stereotyping or discriminating by treating one person differently, than another. So don't go out of your way to really deviate from policy because we really want to take care of this one pregnant worker. Well, someone might see that, and then the next person that's pregnant, well, now you've set a precedent, right? So we want to make sure that we're thinking about, putting these actions in place, being compliant, and then following the policies to the T. And these laws are important too, because, at the end of the day, despite these laws and still some upcoming, 23% of mothers said in a survey last year that they weighed whether or not to leave their job because their workplace lacked reasonable accommodation, or they were worried about the pregnancy discrimination, that these laws are addressing right now. And so that's a big portion of, people who make up half of our population, globally. So these laws serve a wonderful purpose, and it's important to remember that at the end of the day. And then we also have the Pump Act. So this is going to be protections and accommodations for individuals who are lactating. So your FLSA status or number of employees does not matter for this act. You must make a place available to employees to express breast milk. This place should be private and functional. It does not have to be a full-time lactation room, but it cannot be a bathroom. So this will last for up to 1 year after the child's birth. So you have like a defined time frame. And so an example would be, converted offices or conference rooms, wellness or mother's rooms, used clean, repurposed storage room. But it's again just important that it be private, have a lock, have a chair, a table, and an electrical outlet. So we want to make sure that they have everything that they need in a private space that is not a bathroom at the end of the day. The individuals must be completely relieved from duty or paid for the break. So it's either or there. We can't ask for a doctor's note when it comes to this. Again, is for up to 1 year after the birth of the child. And we're coming to you from Atlanta today. So, again, there's other state laws that may apply here, because Georgia's law applies to employers with one or more employees, and the breaks must be paid with no time worked. So while the Pump Act says it's either or, Georgia's law says we can't have them work on these breaks, and you must pay them. So again, with all of these, we want to consider looking at the state laws that could usurp what we have in place and be greater laws. And then, of course, we have FMLA. I think one important thing that maybe gets missed about FMLA a lot is that the employer has to respond within 5 business days of a request. And so if someone comes to you and says, hey, I need to take an FMLA leave, we provide the forms. We need to make sure that we're keeping up with these responses within the defined time frame. And it is within 5 business days of a request for leave that we need to get the forms in their hands, and making sure that they have answers to their questions. And with these as well, we want to make sure we're being consistent with our requirements. When it comes to health certifications, we want to make sure that if we're, asking for health certifications when it comes to pregnancies, that we're doing it every single time. That if you're coming back from a pregnancy and we require a return to work form, that we're doing it every single time, that this has to be done, no exceptions. Because this is something that just kind of opens the door for discrimination. So we want to make sure that when we're doing this, we're being consistent. And we have processes in place when it comes to this as well for deductions, shortfalls, and tracking. So I think with your HRIS, it's important to look at it. And is it tracking the employees and when you're putting them on a leave? Is it sending you reminders of when they're gonna come back? And it's important for these individuals, if you're going out, for example, due to a pregnancy, where you're going out and you need your medical, benefits that you have in place. But you may not be receiving a paycheck during this time, you're just getting the job protection, right? And so these deductions, only happen if you're getting a check. So that's where the shortfalls come into play. Does the system you're using now keep up with, hey, they kept the coverage and we've been paying the bill, right? But this means that the employee still owes us this amount. And then when they come back, either it can all be pulled, from that first check when they come back. Or you can set up a payment plan, say, hey, when you come back, we'll spread, what was missed over 4 checks. And it's important to have these processes, no one wants to put a check in the mail these days. So important to think about these kind of ahead of time, especially if maybe you're sitting there right now with 45 employees, right? And you're about to hit that threshold, and this is something you haven't even thought about. Is my system going to track this? Is my system something I can even grow into, right? Because there is a lot of tracking when it comes to FMLA, and especially once you get into intermittent leave, that's even a different kind of item there altogether. And so another thing with FMLA is we, as the owners, as the person advising HR, we want to explain the job protection. I think that there's a misconception out there that maybe FMLA is paid. And so we also want to make sure that the employees are understanding as we go through this, that this is job protection, not that you're getting paid on your time off. And then, of course, ask them to keep in touch within reason, and remembering that there's a lot of different kinds of leaves for the military, care of a loved one, non-birthing parents, adoption, and that greater rights law applies as well. So these laws can run in tandem. You already have short-term disability maybe running along with it, and short-term disability is always a great thing, that we recommend, because it's not a large expense to the employer, but can really give that employee a peace of mind when they do need to take these leaves of absence. And then state laws, and I've got some here. You see the names of a lot of states up here. The first one is states with paid family and medical leave laws. You'll see the Delaware, Maine, and Minnesota in that first list have years behind them. Those are the years when you must allocate taxes to this state towards their family and medical leave laws. And in some cases, you have to commit, you have to pay taxes into that program before the law even becomes effective. So like, for instance, starting 2025, you may have to start paying taxes and pay taxes through the year 2025. And then in 2026, the employees are able to take advantage of that leave. So it's kind of, sometimes you pay into them in tandem, and sometimes you pay those taxes up front. And then that helps, kind of build up and make that available to the employee. So the ones up top are going to be the ones that are already in place. Even if those dates are ahead of it, they set this out and it's planned, it's already in place and it's happening. And then we have the proposed plans or non-mandatory, in the second one here, and you'll see Illinois and New Hampshire and Vermont are italicized, because these individuals actually have plans in place, but they're just not mandatory. So you don't have to pay taxes into them. But for some of them, it's like, if you work for the state, then this is something that you have to offer. So still, there's a lot of states up here on the list, and, under proposed, not all of them will go through, that's a fact, but it's being discussed everywhere. And this involves, making changes to your handbook. This involves, like we mentioned, setting up taxes to make sure they're going to the right place. We're considering, our remote workforce. This is, and PTO laws that go along with these as well. Everyone has their own sick leave laws now too. So just an example here of navigating where a lot of these cases, these are the greater laws that apply. So while we're offering all of these protections, accommodations, and things, we also want to make sure that we're thinking about this and the atmosphere around it, because everyone is having these discussions of how they're going to make their state leave work. And so now we got best practices. So first line of defense is going to be a custom handbook. If we define these policies, then they're easier to follow, they're easier to build that consistency and leave less room for discrimination at the end of the day, because it's in writing, everyone's made aware, and then we're following through because this is, step A, B, C, and D. And then, of course, yes, the consistency in that policy adherence, making sure that we're not going overboard, because some people think about consistency as, well, we're not offering you what we offer someone else, but it could be we're offering more to you than we offered someone else, and that's not fair. So always think about just the fact that you're setting a precedent when it comes to any changes or policy changes, and it's best to get them in a handbook. And then we have consistent training as well for those in a position of authority. So this is something, the PWFA should be in your handbook as well, along with your no harassment, your equal employment statements, things like that. And, we can put in place, hey, if you have questions regarding the PWFA, then go to HR, right? So we want to make sure that we're defining who to go to in these situations. And so if someone goes to their direct supervisor who's maybe not equipped and hasn't had this training, at least they know that that question goes to HR. Go look it up in the handbook, it says right here, oh, your question goes to HR. I really wish I could help you, but I know that they will. And, just exude that confidence and have them, move along and follow the correct chain of command, essentially. And then we want to be careful of, retaliation also. It's, the stats I have are from 2020, but 56% of all charges filed in 2020 with the EEOC were retaliation. So while we mentioned the numbers like over 81,000 claims, and there was $440 million received for employees, this is a big part of it too, is retaliation when it comes to thinking about all of these laws. With the Pump Act, I have to set up a place for you. Do I feel retaliated against or like a burden at the end of the day, right? And then with documented job descriptions, we touched on that. You have to define the essential functions ahead of time. And then, with documentation, again, the burden of proof is on you. Documentation can't be said enough. If it's not in writing, it didn't happen at the end of the day. So we want to make sure that even when we're having these conversations with the employees about, oh, well, what do you think it is that would help you? And having that back and forth, go have the conversation, agree on something, and then go sit down and send a clarifying email. Hi, just to clarify what we discussed today. So having that something in writing, and as far as what the conversation was about and how that conversation went. And then if unsure, consult with a professional. This law is very new, and so we want to make sure that we're navigating as well as we can with the ways that it, might be subject to interpretation down the road. And so that's what I have for you all. And we really appreciate you being here today. Again, we're HR partners. We're going to take some questions, but this is QR code. If you made it to this webinar, you're signed up to hear about our future ones, but this goes to our website. And so we have a lot of different, options to work with small businesses, especially save you some time, save you some money. We have a system, payroll, benefits, all those good things that we can help you with. So um, I'll leave this up, and then I believe Brenda's going to take us through some questions if we all had those.
Thank you, Taylor. That was a great overview. It was so much important information covered today. We do have great questions. We will see if we could take a couple of them. Of course, if we don't get to yours, please look to participate in our future webinars, or you can also reach out to us directly if you have any additional questions. So let's get started. Taylor, the first question is, what should I do if I have an employee that informally mentions they have just been diagnosed with gestational diabetes?
So if it's an informal discussion, then that's something, where you have the opportunity to say, hey, thank you for sharing that. That must be rough. And it's just a chance to share some understanding and then say, well, let us know how we can help, right? Because again, it's something to offer and say, hey, let us know how we help. Again, that's something that I can't see with my eyes, right? So it's always something to consider on that, but say, or think about some ways that, we can help make that work. If it's something, it just depends on kind of how it's mentioned to you at the end of the day.
Okay, awesome. Next, we have, how do I know whether my company is required to offer FMLA?
Yes, so FMLA is 50 or more employees, and those employees have to be within a 75-mile radius. So if you have multiple locations, then you're actually looking at how far apart they are and where your employees are. So it's kind of different for a remote workplace. But if you have, two different buildings in Atlanta, one's in Norcross, one's in Tucker, or something like that, then that pretty much would apply if both of those added together equal 50 or more.
Okay, awesome. Can I deviate from my policy in the handbook if I know an employee is really struggling and I want to help them?
Yes, and we want you to want to help them. But essentially, the guidance there is going to be setting a precedent. So is this something that you're willing to amend the handbook over? Then that could be something, a case, because again, we want to make sure that we're looking going forward, making sure we're handling things correctly. And if, policies are made to be amended, your handbook should be looked at on a yearly basis. So definitely just always understand and thinking about setting a precedent and thinking about how setting a precedent could always, lead to discrimination, things like that. So it's looking forward when we're talking about a case like that in front of us.
Okay, perfect. I think we have time for one more quick question. This says, what does undue hardship mean?
So that's, yeah, the significant difficulty or expense. And that's easy to say, like I know what it means myself, right? But is, at the end of the day, this is going to be something that's going to be interpreted by an attorney. So best to look at the situation and have an attorney define it for you.
Okay, perfect. Okay, so those are all great questions. We are sorry if we didn't get to yours. Again, we hope that you'll join us for our upcoming webinars in the next couple of weeks. Also, please visit our website to learn more about us and our team. We've been supporting small to medium-sized businesses and their HR teams for the past 25 years. We leverage technology with a team of experts that wraps around your team to be those extra hands, relieve your stress, provide a seamless and one-stop solution. We are a full service solution versus just a technology or self-service solution. So again, thank you so much for joining us today. We do look forward to seeing you at our next webinar, and we hope that you all have a great day. Thank you.
We appreciate you all looking at this topic and showing up today and understanding how important it is. So thank you again, and thank you, Brenda. Everyone have a great little day.